You get home, and there it is, a thick envelope with your name on it. And inside? Court documents. Yep, you're being sued. It is a super stressful moment for sure, but what you do next is absolutely critical. So today, we're going to break down exactly how you should respond, step by step, using Ontario's official rulebook as our guide.
So you've been served with a lawsuit. It can feel totally overwhelming. I get it. But here's the thing. The legal system actually has a really clear, structured process for this. Your first move is your most important one, and it all starts with understanding that document in your hand and, the giant clock that just started ticking. Let's dive in.
All right, here's our game plan. We'll start with the moment that lawsuit arrives and the deadlines you're up against. Then, we'll get into the nitty-gritty of how to actually write your defense. We're also going to look at the serious, and I mean serious consequences of ignoring a lawsuit. And finally, we'll wrap up with why your response is so fundamental to the entire case.
Okay, Section 1. Let's talk about what happens in that first moment, the formal start of a legal action.
So that document you're holding, it's called a statement of claim. The terms here are pretty simple. The person suing is the plaintiff, and you, well, you're the defendant. You can think of this document as their side of the story, laying out all of their allegations against you. And now the court needs to hear yours.
And that brings us to our second and maybe most urgent point. The second you are served with that statement of claim, you are officially on the clock. This is not a drill. The rulebook, specifically Rule 18.01, lays out your deadline to deliver what's called a statement of defense. If you were served right here in Ontario, you've got 20 days. If you were served somewhere else in Canada or in the United States, that bumps up to 40 days. And for anywhere else in the world, you get 60 days. And just to be crystal clear, these aren't suggestions. They are hard and fast deadlines.
But let's be real for a second. 20 days can fly by in the blink of an eye, right? What if you need more time to get your thoughts together or find a lawyer? Well, the good news is the rules actually anticipate this and give you a specific tool you can use. It's called a Notice of Intent to Defend, and as laid out in Rule 18.02, it's a simple, formal document that you file with the court. It doesn't have your arguments or your story in it. It just puts everyone on notice that you're not ignoring the lawsuit and that you fully intend to file a proper defense. And here's the real magic. Under Rule 18.02, just delivering this notice automatically buys you an extra 10 days to get your statement of defense ready. It's such a simple step, but it can give you some incredibly valuable breathing room. So you've got your deadline figured out. Now for the main event. What actually goes into a statement of defense? This isn't just about casually telling your side of the story. It's about following some very specific rules of pleading.
Okay, Rule 25.07 breaks it all down for us. First, you need to go through the plaintiff's claims, basically paragraph by paragraph, and admit any of the facts that are actually true. Easy enough. Second, you deny the allegations that you disagree with. But, and this is so important, a simple denial isn't enough. Step 3 says that if you have a different version of events, you must state it clearly.
And this slide right here shows you the difference perfectly. Under Rule 25.07, just saying the allegation is denied, that's not going to cut it. You have to provide your own set of facts. You can't just tear down their story. You have to start building your own. It's a proactive approach, and it's exactly what the rules demand for a solid defense.
Now, beyond just responding to their facts, you might have something called an affirmative defense. Rule 25.07 says you have to plead anything that might take the other side by surprise. It's all about fairness, preventing a trial by ambush. This is where you bring in a new fact or a legal argument that could stop the lawsuit in its tracks. A classic example, maybe the plaintiff just waited too long to sue. So even if everything they said was true, if the statute of limitations has expired, your affirmative defense could win you the whole case. Okay, we've talked about what you should do. Now we absolutely have to talk about what happens if you miss your deadline, or even worse, if you do nothing at all. The consequences, well, they're swift and they are severe. If you don't deliver your defense in time, the plaintiff can go to the court and ask to have you noted in default. This is a formal step under Rule 19.01, and it's basically a procedural knockout. Once you're noted in default, you effectively lose your right to even participate in your own lawsuits. This is the most shocking consequence, and it comes straight from Rule 19.02. If you are noted in default, the court considers you to have admitted that every single allegation in the statement of claim is true. Let that sink in. Your silence is legally treated as a full confession. And it just gets worse from there. As Rule 19.02 explains, you can't file a defense anymore. You can't take any other step in the case. You won't even get notices about what's happening. The plaintiff can then just move ahead and get a court judgment against you for money, for property, whatever they asked for. And you will have had zero say in it. The cost of silence is quite literally everything. So this brings us to our final and I really think most important point. After all that doom and gloom, why does this chunk of paperwork matter so much?
Your statement of defense is so much more than just a legal document. It is your voice. It is your official, on-the-record chance to tell your side of the story. It's the foundation that frames the entire dispute from your point of view and sets the stage for everything that comes next. Ignoring it means giving up your right to even be heard.
So when you're staring down a lawsuit, remember, it's not just about defending yourself. It's about proactively and powerfully asserting your version of the truth, which really makes you wonder, doesn't it? In the world of litigation, is a strong, well-crafted defense actually the best offense you could possibly have? Something to think about.